Silence, call tries.
Before you start, may we crave your indulgence and ask you please to slow down?
Yes. I apologise.
I know that you're thinking quickly and you want to get through a lot of material, but we also want to make an accurate note.
Yes, and I'm sorry for speeding up at various points particularly, but I will endeavour to ensure it is a more even pace this afternoon.
Thank you very much. Yes, now where are we? We're on to
Margin of appreciation at the moment, and if I could invite the court please to turn to tab 43 in bundle B, the decision of AP, Garçon and Nico. And if I could pick it up please from page 1632, using the bundle numbering. Paragraph 83 sets out the nature of the applicant's complaint in that case. It was a complaint about a refusal of requests to have the indication of gender on birth certificates corrected on the grounds that in order to do so, one had to demonstrate an actual suffering from a gender identity disorder, and that the change in appearance was irreversible, and that in order to do that, one was compelled to undergo prior surgery or treatment entailing irreversible sterility, and they relied on Article 8 of the Convention on that basis. Turning please to the next page, 1633, the merits. The court started by asking itself the preliminary question about the applicability of Article 8 of the Convention, consistently with our position but not the respondents'. And you will see the very familiar refrain from the previous cases, in particular Van Cook, that we've looked at, paragraph 92. Elements such as gender identity or identification, names, sexual orientation and sexual life fall within the personal sphere protected by Article 8, and the freedom to define one's sexual identity is one of the most basic essentials. At paragraph 95, I simply emphasise this in anticipation perhaps of Mr. Reedy's submissions, they confirm that the right to respect for private life under Article 8 of the Convention applies fully to gender identity as a component of personal identity. This holds true for all individuals, including, we say, individuals who identify as non-gendered, such as the appellant. Then moving to the question about whether it's an interference, they first considered whether it was interference or positive obligation, and in line with the approach also adopted in Hämäläinen, they adopted the approach of considering it as a positive obligation. The question of the margin of appreciation was dealt with from paragraph 121, that's page 1640, and paragraph 121, the court effectively sets out paragraph 67 of Hämäläinen. You'll see at the end of that paragraph, they say, see in particular, Hämäläinen, paragraph 67, and the references cited therein. They then apply those principles to the present case, so at page 1641, paragraph 122. They note that the contracting parties are divided as regards the sterility requirement. There is no consensus on the subject. It further notes that public interests are at stake, the government pleading in that regard the necessity of safeguarding the principle of the inalienability of civil status and ensuring the reliability and consistency of civil status records, and that the present case raises sensitive moral and ethical issues. But the court continues, nevertheless, The court also notes that an essential aspect of the individual's intimate identity, not to say if their existence, is central to the present applications. And they point out that the issue of sterilisation goes directly to their physical integrity, and secondly, because the applications concern the individual's gender identity. And the court then refers back to cases such as Pretty and again Van Cook at paragraph 69, which the court has already seen, and equally paragraph 75. And finally, the final sentence of paragraph 123 is, this finding leads it to conclude that the respondent state had only a narrow margin of appreciation in the present case. So that is a finding of a narrow margin, despite there being no consensus on the subject by the contracting parties. And we say that is the right position to adopt. And of course, AP, Garçon and Nico is a decision of 2017, so a much more recent decision, but putting into effect the same principles that were set out in Hämäläinen. And so when in Hämäläinen it says, nevertheless, if there is no consensus, we say that the nevertheless equally can be where there is such an important facet of the individual's personal identity, their gender identity, that should, we say, lead a court to conclude that a respondent state would only have a narrow margin of appreciation in such a case. Now, it's common ground, of course, that the margin of appreciation does not directly apply in domestic cases in the sense used in the Strasbourg jurisprudence. And one sees the way it is put in Steinfeld. If one could put away bundle B, please, and take bundle A2 at tab 20. And I recognise, of course, Steinfeld is a discrimination claim, but I will deal with the points of principle here because they're obviously also relevant to my articles in Article 14. Page 930, using the bundle numbering, at paragraph 20, one sees the start of justification of the arguments. And for completeness, just to note, so what was said in that case was that the government had accepted that access to civil partnerships fall within the ambit of Article 8, that there was a difference in treatment, and it was on the ground of sexual orientation. But what was said at paragraph 21 by Sir James was that the government wanted to take a better sense of how civil partnerships would come to be regarded after the same-sex marriage became possible before taking a final decision on their future. And that's obviously relevant to the question of the approach in this case. But so far as the propositions on justification are concerned, Sir James did not take any particular issue with any of them. And, of course, at paragraph 3, subparagraph 3 of paragraph 20 above, one of the propositions was where the difference in treatment is based on sexual orientation, a court must apply strict scrutiny to the assessment of the asserted justification, and particularly convincing and weighty reasons to justify it are required. So far as how the margin of appreciation plays out in a domestic level, that was discussed and considered from paragraph 28 to paragraph 29 in particular, and the court referred to Baroness Hale's speech in VG, noting that, this is paragraph 28 on the internal page 931, it is clear that the doctrine of the margin of appreciation as applied in Strasbourg has no application in domestic law. The Strasbourg court will allow certain freedom of action to member states, which may mean the same case will be answered differently in different states, or even different legal systems within the same state. This is particularly so when dealing with questions of justification, whether for interference of one of the qualified rights or for a difference in treatment under Article 14. National authorities are better able than Strasbourg to assess what restrictions are necessary in the democratic societies they serve, so to that extent, the judgment must be one for the national authorities. Paragraph 29. The National Court must confront the interference with the Convention right and decide whether the justification claimed for it has been made out. It cannot avoid that obligation by reference to a margin of appreciation to be allowed to the Government or Parliament, not least in the sense that expression has been used by the European Court. The Court may, of course, decide that a measure of latitude should be permitted in appropriate cases. Before Mrs. Justice Andrews, the respondent had relied on Lord Hope Craighead's statement in Kebeline, when he'd spoken about difficult choices being made by the executive or the legislature between the rights of the individual and the needs of society, and in some circumstances it would be appropriate for the courts to recognise this as an area of judgment within which the judiciary will defer on democratic grounds to consider the opinion of the elected body or person whose act or decision is said to be incompatible with the Convention. Pausing there, what we say, of course, here is, and we reiterate, there is no balance and choice to be made between the rights of the individual and the needs of the society for the reasons that I've already explained. This is not a competing interest case. Paragraph 33, if I start at 32, in fact, in relation to, this was the Secretary of State, in that case's submissions, that what was described by Lord Mance in M as a margin of discretion was analogous to the margin of appreciation. The Court noted that the margin in cases where distinctions are made on the ground of sexual orientation is narrow, and the margin of discretion available to the Government and Parliament in this instance, if it exists at all, must be commensurately narrow. And they say, moreover, as Ms Monaghan has submitted, where the difference in treatment is based on sexual orientation, a court must apply strict scrutiny to the assessment of any asserted justification, and particularly convincing and weighting reasons to justify it are required. We say that the protection given to people on the grounds of sexuality, sex, is not different to that in relation to the grounds of gender identity. The affected class is, we say, for these purposes the same. Both of those particular statuses derive from the integrity of the person. So we say that any margin of discretion or a discretionary area of judgment, as it might be put, should be narrow in these circumstances. The respondent submits that a wide margin should be accorded to her within the fair balance exercise because the decision whether or not to recognise non-binary people raises difficult, controversial and sensitive issues. At the risk of repeating myself, the decision is not to recognise non-binary people per se. The question is whether to permit individuals who identify as non-binary, including in particular non-gendered, to apply for an ex-passport. That, we say, does not raise difficult, controversial or sensitive issues. In any event, we say it is precisely because of such difficult issues that, if they do arise, a margin is narrow. And we've referred in our skeleton to the G case, which is authorities, I don't ask my lady, my lord to turn it up, authorities, bundle A1, tab 6, at page 176, paragraph 48. It's because the fundamental rights of a minority group are actually in play that one should consider the care of the discrimination claim, and that is in relation to a discrimination claim which it's suggested is always appropriate for judicial scrutiny, and the more contentious the issue is, the greater the risk that some people will be discriminated against in ways that engage their convention rights. It is for the courts to see this does not happen. It is with them that the ultimate safeguard against discrimination rests. Applying those principles then, and our starting point is that it is a narrower margin of appreciation than the Secretary of State would submit. Our position is a simple one. The interference suffered by the appellant is very significant. It clearly passes the threshold for consideration on any view. And my lady, my lords will have had the opportunity to read Per's second witness statement. The three aims identified by the respondent are, in our submission, not nearly sufficient to outweigh on a balancing exercise the applicant's rights. Passports have been and continue to be considered in isolation from other elements of government in relation to trans people. There is simply no basis for the assertion that they cannot sensibly be considered separately in the context of non-binary persons. So far as fraud and identity theft is concerned, there is no difference, so far as non-binary, non-gendered persons is concerned, to the current position that applies to trans people. Security at borders, the evidence, as I've explained, is based on the removal of sex markers rather than the use of the X marker, and fails to take into account the current existence and use of such passports internationally. So far as consensus is concerned, I accept that I cannot point to the same proportion as in Goodwin, but we do say that there is clear and consistent evidence of an international trend, including in contracting states, and in any event, I say that particular factor does not outweigh the other factors as demonstrated in the AP, Garçon and Nico case.
Consensus did not outweigh the other factors.
As demonstrated in the AP, Garçon and Nico case, to which I've just taken the court, where despite the absence of consensus on sterilisation in that case, the court found that there was a positive obligation which arose because of the importance and significance of the right in play, that is, gender identity. The respondent relies on three further factors which they suggest point away from the existence of a positive obligation under Article 8. Now, the first is that the government is keeping the status of non-binary people under consideration and active review. Now, I've already flagged up the key dates. The first time that the issue of ex-passports was indicated would be reviewed was in 2010. For the court's reference, that's Supplemental Bundle, tab 15, page 174. That's a letter of the HMPO of 29th of September 2010.
Sorry, page
174, 174. It wasn't until February 2014 that the internal review was published, and we've seen that at Supplemental Bundle 16, page 176. Although it appears from the evidence of the respondent that it was actually undertaken in late 2012, 2013. The do-nothing option identified in that internal review indicated that doing nothing would involve regular updates and reviews. That was at page 181 in that document. Since the internal review that we've seen, there has been no formal review of the position. That was confirmed in September 2015, Supplementary Bundle 20, tab 24, page 238. And I've already explained that although they said at that point they would be seeking updates through the ICAO, they weren't sought until January 2017. Further information was sought in October 2017, none of which we have seen. And what happened then, as my Lord Justice Irwin pointed out, is, according to Mr. Farminer's statement, that effectively that work has been put on ice, pending, he says, the work to be done by the Government Equalities Office. In our submission, that cannot be a valid reason for not continuing to analyse the results of the questionnaire that had been sent out on the 9th of October. On any view, that information was relevant to the work to be done by HMPO, whether by itself or at a cross-governmental level. And in any event, that work was apparently undertaken on behalf of the advisory party of the ICAO, who were waiting to be updated on the survey on this issue, but as far as we understand it, wait in vain. More fundamentally, as a matter of principle, we do not see how keeping the situation under review could be a legitimate aim justifying interference with the appellant's rights or stopping a positive obligation from Article 8 arising. We say that any such suggestion would be fundamentally inconsistent with Steinfeld, where the Secretary of State's argument, which I've just referred to at paragraph 21, wanting to have a better sense of the issue before a final decision could be taken was a legitimate aim, was emphatically rejected. The second other factor that's relied upon by the Secretary of State is significant administrative and cost burden. This is referred to at paragraph 37 of the respondent's skeleton, reference core bundle, tab 4, page 67.
Paragraph 37.
37, core bundle, tab 4, page 67. But this is only prayed in aid in relation to the recognition of non-binary people, quote, more generally, that would carry a significant administrative and cost burden. So the burden that they are referring to only arises if the court accepts that it is legitimate for the, we say, interference to be continued, pending consideration of other issues. And I've already explained why I don't say that is legitimate. But the cost burden only arises if effectively the Secretary of State has succeeded on showing that it is not sensible to consider passports in isolation. There is no argument, as we understand it put forward, that the cost of considering passports in isolation, the £2 million figure, is a significant administrative and cost burden in this scheme. The third factor is the number of people who might benefit from an ex-passport. And the respondent points to the statistics that were collected last year that show some 7,500 respondents to the LGBT plus survey, which identified as non-binary. I pointed when we were last looking at Goodwin to the number of transsexuals estimated in 2002 to be some 2,000 to 5,000. A smaller number than even the people who answered the survey, far less than if one extrapolated from the survey results to the population more generally. It's quite clear that even that smaller number at the time of Goodwin was not a bar to a positive obligation arising in that case, nor is it a bar here. One then still has to consider the question of proportionality. Again, our position is very straightforward. The aims identified are not sufficiently important to justify the limitation of a fundamental right. And in particular, if we are right that Article 8 is engaged, if we are right that there is this interference, effectively what the Secretary of State is saying is we should continue to interfere with your rights in every respect so that we can have time to think about how to deal with those, rather than cease to both discriminate and interfere with your rights in one respect in relation to passports. And so we say that the aim of considering in the round is clearly not proportionate when one looks at the measure that is actually challenged, where there is a very straightforward route through as to how to ensure no more discrimination and no more interference with the appellant's Article 8 rights. They're not rationally connected, the aims identified, either the security aims, which are simply, we say, ill-founded, or the administrative coherence point, for the same reasons I've explained before. And so our position is, on any view, the fair balance simply has not been struck. I can move then to Article 14, if I may. And the judge's approach to this is set out in his judgment, which is in the core bundle, tab 8, page 144.
So that it could help me if you could give paragraph references, because I have the judgment.
Yes, of course. It's paragraphs 132 to 135. So at 133, he set out the approach, the proper consideration of Article 14 in guiding Godin Mendoza. We don't have any disagreement with that as being the proper approach and direction. He sets out at 134 as it were, his analysis of those questions as he goes through. The first question, which is whether or not the claimant's non-gendered identification falls within the ambit of Article 8, he answered in the affirmative, having already found that to be the case. We say, again, We are right on that, and the respondent is wrong, but I will hear Sir Jade's nuanced argument before trying to proceed further with why we say that's correct. But we say our arguments are the same in this context. The question, though, that's related to whether or not non-gendered status forms part of gender identity for the purposes of Article 8 is also connected to the question of other status, that is, what is required under Article 14, because the respondent also argues that the appellant's status as a non-gendered person simply doesn't fall within other status for the purposes of Article 14. We say that's wrong for the same reasons, but the other aspect of that is it cannot be, because they say that the personal characteristic relied upon is that defined by the differential treatment itself. That's the skeleton of the respondent at paragraph 45. Now, we don't agree with that analysis. Now, the question about whether the personal characteristic can be defined by the differential treatment was considered in Stott, which is relied upon by the Secretary of State. And in Stott, just if I might turn it up very briefly, that is tab 23, so it's in column 2, tab 23. And this is in relation to discrimination arising from a particular status as a particular type of detained prisoner. And it was Lady Black who dealt with this issue, starting at paragraph 56, which is the paragraph relied upon by the respondent. Lady Black set out with, prior to the decision in Clifton, United Kingdom, so the Strasbourg decision, and just if we may be rolling down, subparagraph 4, this is at G on page 1013, that's internal page 1850, but the bundle number 1013, paragraph 56, subparagraph 4, there was support for the view that the personal characteristic could not be defined by the differential treatment of which the person complained. The other paragraph relied upon by the Secretary of State is 63, where Lady Black returns to those propositions set out at paragraph 56 and says, it seems to me that the subsequent authorities in the Supreme Court could be said to have continued to proceed on the basis of propositions 1 to 3, which have also continued to be reflected in the jurisprudence of the European Court. Proposition 4 lives on in R.V. Doherty, but perhaps need to be considered further in the light of its rejection in Clift and the United Kingdom. It says, see further below. And that consideration was dealt with from paragraph 72 onwards, page 1018, and that's whether the treatment must exist independently of other status. And I don't need to take my lord and my ladies through the analysis, but the analysis ends at paragraph 75 at the foot of 1019. In all these circumstances, I would be cautious about spending too much time on an analysis of whether the proposed status has an independent existence, as opposed to considering the situation as a whole, as encouraged by the European Court in Clift and the United Kingdom. We would adopt the same approach here, but in any event, we would say that the other status does arise independently of the differential treatment. And the reason for that is that the starting point for the appellant's case is that under Article 14, persons whose gender identity is congruent with their biological sex, or trans persons whose gender identity is the opposite to their biological sex, but still in binary terms, can all apply for and obtain a passport which accurately reflects their gender identity.
Could you say that again?
Of course.
Whose gender characteristics are non-congruent.
Yes. So, a person whose gender identity is congruent with biological sex can apply for and obtain a passport which accurately reflects gender identity. A trans person whose gender identity is the opposite to their biological sex, whether female, male, male, female, they can also apply for and obtain a passport which actually accurately reflects their gender identity. And I took you to the HMPO note on how one goes about doing that. That's the relatively informal process referred to in Rees. And the distinction is that as a non-gendered person, the appellant is unable to do so because Per must either apply for and obtain a passport which misrepresents Per's gender identity, or choose simply not to apply for one. And we say that as such, the appellant, and indeed others of the affected class in the non-binary category, is treated differently to those whose gender identity is either male or female, whether they be cisgender, as it's referred to, i.e. those whose gender identity matches their biological sex, or trans persons. Now, the availability of X as a designation in a passport would remove that differential treatment, because it means that the appellant and others in the affected class would no longer have to misrepresent their gender identity in making an application for the document, and no longer have to bear and use a document for identity purposes as well as travel, recording that misrepresentation. So we say that the fact that the appellant does not seek a passport which identifies them as non-gendered is nothing to the point. The differential treatment arises because of the analysis I've just indicated, because the appellant is required either not to apply for the document because it doesn't match with her gender identity, Per's gender identity, or to apply but misrepresenting Per's gender identity in doing so. And we say that is not only the answer to the other status point taken by the respondent. In other words, that's why the other status does not derive from the treatment complained of. It is independent because it is based on Per's gender identity, but it also goes to the difference in treatment point. Now, there's a disagreement between the parties as to the way in which we put our case below. We don't accept we've changed our position on difference of treatment, and I just invite the court to read paragraph 79 of the skeleton below, together with paragraphs 25.1 and 25.4 and 50, which we say make clear that our position has always been as I have just described it.
All from your skeleton below?
Yes, if you wouldn't mind. I don't want to take up time just going through that. Yeah. And that's at core bundle 10 from 163. But in any event, it doesn't appear to be in dispute that it's better to concentrate on the reasons for the difference in treatment and whether they amount to an objective and reasonable justification than on the identification of an exact comparator. And that is per Baroness Hale in AL Serbia. Again, I don't ask you to turn it up, but that is paragraph 25 of AL Serbia. Authorities...
Just before we leave
Yes.
other status, would I be right in saying that actually cases where a decision has gone against the claimant on the basis of not satisfying other status are really vanishingly rare? I mean, the court nearly always seems to find a way of satisfying that requirement.
Yes, that's fair. But there is a point on that, which is the extreme, as it were, breadth of it is, I think,
Yes.
captured by the KGB officers whose personal lives were said to be affected by restrictions, or I can't remember the name of it, restrictions by their working life. But yes, the ambit within which the court has found to be covered by Article 14 is very broad indeed. Yes, we'd entirely agree. Sorry, just also for the note, I'm sorry, I'm reminded of the PV and Spain decision. We refer to this at paragraph 35 of our skeleton. This makes it clear that gender dysphoria is a condition covered beyond any doubt by Article 14. Yes. Yes, it's in footnote 6. And PV and Spain can be found at tab 37, and it might just be worth turning PV and Spain up.
Which bundle?
I'm so sorry, bundle B. Bundle B, tab 37. At the front of that tab, you have a certified translation of the original, which is in French. It's at the back of the tab from page 1408. But at the top of page 1406, the court considered that although the issue in the present case is not a matter of sexual orientation but sexual dysphoria, so 1406, paragraph 30.
Thank you.
So just to put that in context, paragraph 29, the court had referred back to the particularly serious and convincing reasons being referred to justify different treatment with regard to rights falling within the ambit of Article 8, where sexual orientation is an issue. In PV in Spain, the court noted that although it wasn't sexual orientation in that case, but sexual dysphoria, it considered that transsexuality is a notion covered beyond any doubt by Article 14. And just to note there, transsexuality was the type of sexual dysphoria that the applicant PV in Spain held. But we say that PV in Spain is a clear indication that gender dysphoria or sexual dysphoria, in the original French it's dysphoria de genre, it's gender dysphoria, is covered by Article 14, as in PV in Spain. The real problem, we say, that led the judge into error was the consideration of comparators, which is what led him into finding that it was arguable, it wasn't a conclusion, he said it was arguable, that there was in fact equality of treatment between the groups, because he said, well, no one can apply for an ex-passport, so you, as a non-gendered individual, are in no different position from a cisgender, a person who identifies congruently with their birth sex, and so there wouldn't be any difference of treatment. We say that's wrong because the wrong starting point, and I've set out the analysis we say of what we say the difference in treatment actually is. But it seems to be that the approach to comparators may have led the judge into that particular error to find that even arguable. When it comes to justification, the principles are not in dispute. The burden of justification falls squarely on the respondent. It is not the scheme which needs to be justified, but its discriminatory effect, and the proportionality analysis that needs to be undertaken is that set out in Aguilar-Keeler and such cases, and summarised, just for your note, at paragraph 41, helpfully at Steinfeld itself most recently. There are 3 points in principle, though, in which we don't agree with the Secretary of State. The first is the margin of discretion. As I've indicated, we don't repeat our arguments as to why we disagree, but we say that it is absolutely clear in the context of Article 14 that strict scrutiny is required. Now, we also then note that PV in Spain did find that particularly serious and convincing reasons are required to justify different treatment, not only when on the ground of sexual orientation being an issue, but there by reference to gender dysphoria. And thirdly, we relied upon the point made by Lord Kerr in Steinfeld, and I'm sorry, I know you may still have Steinfeld open, but if not, it's back in Authorities Bundle A2, tab 20, on what is required for an aim to be legitimate. paragraph 42 on page 934. Lord Kerr referred back to Lord Bingham's statement in A and the Secretary of State of the Home Department. What has to be justified is not the measure in issue, but the difference in treatment between one person and a group or another. And then Lord Kerr's gloss on that. To be legitimate, therefore, the aim must address the perpetration of the unequal treatment, or as Miss Monaghan put it, the aim must be intrinsically linked to the discriminatory treatment. Turning back, one can see the context in which that finding is made from paragraph 15, turning back to page 929, where Lord Kerr notes that the question whether the legislation pursued a legitimate aim occupied centre field on the hearing of the appeal before this court, and in particular the argument focused on the question whether the legitimate aim required to be intrinsically connected to the unequal treatment, whether the legitimate aim required to be intrinsically connected to the unequal treatment, or whether it was enough that the government's aim was to take the time necessary to decide which form of removal of the discrimination was the most appropriate. Now, we don't understand there to be anything unprincipled or surprising about Lord Kerr's analysis, and nor did he cast doubt on the test in A. All that's being said is that what was required for an aim to be legitimate, which the respondent had suggested was wait and see, was that it be, as it were, intrinsically connected, and wait and see was not. Now, the learned judge below indicated at paragraph 135 that he didn't need to consider the issue any further because he said it was inevitably the case that any such difference in treatment under Article 14 is objectively justifiable for the same reasons as he'd found in relation to Article 8. And those reasons at paragraph 130 of the judgment, I might turn to those reasons were that the current policy not to permit is, does not amount to an unlawful breach of Article 8, and the reasons for that, paragraph 130, was that he said that the government was entitled to consider the issue raised in these proceedings further, and in the light of recent and current research which is being undertaken, in order to provide what Kate O'Neill, who was the deponent on behalf of the Government Equalities Office, states, will be governmental policy towards non-binary people for the foreseeable future. He also, about midway down that paragraph, he says, it seems to me that these matters, together with the government's justifiable concerns about security, are legitimate aims, in that it's in the interest of society and good governance for these matters to be the product of appropriate research and careful evaluation, and that in the interim, the current policy in relation to the issuing of passports is a proportionate means of achieving the aim of providing a coherent and consistent policy towards those who identify outside the binary concept of gender across all governmental departments and legislation. So those were the reasons which he then reflected in paragraph 35 as being the answer to why a difference in treatment is objectively justifiable is for the same reasons.
35 or 135?
Sorry, 135, that's my error. I'm so sorry.
Yeah.
But of course, we say that wasn't correct, and we refer to the dicta of Sir James Munby in Re A, as set out in our skeleton at paragraph 38, and what's not in dispute. What must be justified is the discrimination, not just the underlying measure. And that error was highly material here, because the first identified aim, that is, effectively wait and see by any other name, as characterised at paragraph 130 of the learned judge's judgment below, was not intrinsically linked to the discriminatory state of affairs, and was just as in Steinfeld a plea for time for evaluation, because that is almost exactly what, and I don't criticise the learned judge for it because Steinfeld came out shortly after this judgment, but that is exactly what the Supreme Court then said wasn't a legitimate aim when it came to discrimination. So we do say that the judge erred in that respect, in any event. The respondent, perhaps unsurprisingly in the light of Steinfeld, now doesn't seek to rely upon that aim that's identified at some length at paragraph 130 by the judge below, but relies upon the same three aims upon which it seeks to justify in relation to Article 8. So administrative coherence per se, and security both in relation to identity theft and fraud and security at borders. And paragraph 54 of the respondent's skeleton, she argues that the first of those aims, that's administrative coherence in principle, is not analogous to Steinfeld on the basis that acceding to the appellant's claim would mean changes in other disparate areas of law and policy. And you've already heard from me at some length on why it wouldn't mean changes. It is entirely a matter of choice rather than necessity. So we say the suggestion that Steinfeld is different because the policy in Steinfeld concerned the impugned measure only really doesn't assist. That's precisely the same position here. The impugned measure is in relation to the passport policy, not other matters. And we say that what is clear is that really what the respondent wants to do is to recast that first aim as administrative coherence, to buy herself more time, which would otherwise be available under the approach in Hooper. And that's referred to at paragraph, I think, 54 of the respondent's skeleton as well. And Hooper is at authority bundle A2 28A. I think that's one of the new authorities that the respondent put into your bundles this morning, lady. At paragraph 62, we can see that just for clarity, it's in the same bundle as we have open, I hope still, at the back. Another one has gone in behind it, A has gone in behind it, but I don't propose you to take A.
Sorry, which tab are we looking for?
Tab 28A.
28A, thank you.
A handwritten tab that's been tucked in by the associate.
Look left.
Perfect.
Look left.
Ah, okay.
Where do they go?
Thank you.
They go at the back of A2.
Back of A2, yes. And you also have A, if you've got A to hand as well. A in the Secretary of State for the Home Department.
28A, 28B.
Yep.
Yeah. A and B. I think they might have come to you with tabs, but well, thank you. We thank the respondent.
And then
for
there's
that.
a 59A as well.
There is, and that goes at the back of C.
Thank you. You want us to look at Hooper?
Yes. And in the meantime, my learned junior reminds me it's Steinfeld, not Steinfield, so it's not just Finnish that I can't pronounce, it turns out. So Hooper at paragraph 62, which starts at the bottom of page 1698.
In Hooper.
In Hooper, yeah.
That's not paginated bundle, so we'll just work from
No, just
paragraph
from the
numbers,
top,
please.
exactly. It's a new edition from the respondent. So top is with classic weekly law report numbering.
Right. 1698.
1698. And this is in consideration of Walden and Liechtenstein. And it was in relation to, as it were, what happens after a finding of unlawfulness. And at 62, Lord Hoffman finds the decision puzzling. He notes it may be reference to the way it was argued, because it concentrated on the decision whether the state court should have set the contested provisions aside. But he says, I can quite understand if one has a form of discrimination which was historically justified, but with changes in society has gradually lost its justification, a period of consultation, drafting and debate must be included in the time which the legislature may reasonably consider appropriate for making a change. So we don't dispute that as a proposition in principle, of course, but what we do say is one has to look at what is actually proposed in this case. Because in substance, what the Secretary of State is trying to do is achieve the same by the back door as it would and had done before the learned judge below, i.e. time to reflect, consider and decide whether or not to, as it were, implement some wider policy in relation to non-binary individuals. But this is against a background where, in relation to passports, and that is of course our focus, in relation to passports, nothing's been done effectively for 10 years. And in particular, nothing has been done for the last 2 years since the witness statement of Mr. Woodhouse. And that's a very unattractive starting point for the Secretary of State to seek to rely upon Hooper and say, well, actually, even if we are wrong and the discrimination isn't justified, we should have more time as a result. And we do note the point made by Lady Justice Arden, as that she then was, in her dissent in Steinfeld in the Court of Appeal. If I can just give your Ladyship and Lordships a reference, that's Bundle A2, tab 16, page 781, and the reference is at paragraph 19, that the Secretary of State could not justify discrimination where her policy of wait and see had no time limit. And that's just the same here. There is no time limit in relation to this wait and see policy proposed in this case. The second point we make is that the respondent's submissions on this are predicated on the court concluding that neither of the aims relied upon her, that's administrative coherence or security in both its limbs, are legitimate, because she's assuming that she's lost that point, and although not referred to expressly, not proportionate. So it can't be right that latitude is required to show and consider in what time and form any legislative change to redress the difference in treatment should be made, and that's the skeleton of the respondent, paragraph 55. Now, Hooper, of course, did concern a situation where legislation was necessary to rectify discrimination, but that simply isn't the case here. So we say there are a number of problems with the Secretary of State's response in relation to the discrimination claim. Perhaps the most significant of them is that nowhere has the respondent actually sought to engage with the four-stage proportionality test. Now, the burden is, of course, on the respondent to justify the discriminatory measure, so I will address any submissions that are made on that four-stage proportionality test in due course once Sir James may have made them. Can I move then to the question of the common law public grounds in relation to the decision? We call them the public law grounds. We had always challenged the policy, the passport policy, on conventional public law grounds on two main bases: relevant and irrelevant considerations vitiating the respondent's decision-making process, and the irrationality stroke unreasonableness of the conclusion to maintain the policy in force. As I've indicated, the policy has been in force since at least 2010, although it's fair to say it wasn't entirely clear that they actually realised they had a policy at that point when the...
You're speaking up again.
I promised, didn't I? The policy has been in force since at least 2010. And that's not the first time that the appellant had written to HMPO. That's the second of the documents. The first time is 95. But 2010 is when we know the policy was there. But it doesn't appear to have been recognised as such. There's all sorts of confusion over what they thought might be the case. For example, whether actually any other country had ever adopted an ex-passport policy. And the judge recorded at paragraph 142 of his judgment that we had submitted that the continuation of the policy must have been based on a relevant reasoned decision which is susceptible to judicial review. Now, that's right, but that's not to say that the policy itself per se is not amenable as a current policy to review on the grounds of rationality or reasonableness. And we do that, but where it comes to challenging a policy on the grounds that relevant matters were not taken into account and irrelevant matters were, then we do need to identify a point at which that decision, either to implement a policy or to maintain it, is taken. And the judge at paragraph 142 of his judgment indicated that the difficulty with our argument is seeking to identify the date of the relevant decision. And he noted that we hadn't sought to identify it with any precision, but we'd relied upon correspondence, reports and witness statements. Now, it's very difficult for us to identify with any precision when a decision was taken. It might be quite easy for the respondent, but they haven't chosen to do so. But to the extent that there's any criticism of our position by the learned judge below, we don't accept it. I've set out at the beginning of these submissions, and the court has the chronology, which really identify the uphill struggle that the appellant has faced over many years trying to get clarity and engagement from the Passport Office on its policy in relation to ex-passports. The best we can do is to identify two particular points at which a decision to maintain the policy must have been taken. The first we can derive from the respondent's own skeleton, paragraph 35, little Roman 1, that at some point following the internal review, which was undertaken in late 2012 to 13, the respondent decided that no changes were required. So that's the adoption of the no action option, the do nothing. Now, there's no date provided for that decision, and we can only logically infer it must have been based on the matters set out in the internal review. It's not suggested that there was anything else upon which that decision was made. And we say the second point at which there must have been a decision to maintain this policy was following the report on transgender equality by the Women and Equalities Committee in order for the government to respond as it did in July 2016. And the court has that at Supplemental Bundle tab 30, page 252. We don't have specific decisions identified by the Secretary of State. We don't have what was put before a minister at any particular point, and that's why we've built our case on correspondence and reports. We have, as the learned judge noted, of course, also taken into account witness statements. And before we had the witness statement of Mr. Woodhouse in particular, as well as Ms. O'Neill. But the difficulty with those statements, which were served in October 2017, is they do not purport to explain the respondent's decisions to maintain the policy at the time when the respondent took those decisions. So the very real risk, I say inevitable risk, is that those witness statements represent an ex post facto justification, or as it were, a view taken as at October 17, why our arguments were wrong and they should maintain the policy, rather than a reflection of the matters that actually were taken into account, or were not taken into account, at the time that a decision to maintain the policy was made. And this matters for two reasons. The first is the principle, which is, we suggest it should be a concern for this court, as it ought to have been for the court below, that where a public body doesn't identify when a particular decision is made to maintain a policy, we find out years later there's been an internal review and the do nothing option has been followed. We find that out effectively because they do nothing. But we're never sent a decision letter or anything like that. In that circumstance, by failing to identify the decisions, and on what basis, if the learned judge's approach below is followed, a respondent can simply abandon reliance on a particular matter with no consequence, even if that matter was an irrelevant one. And this is most starkly illustrated by the learned judge's finding at paragraph 144, that's Core Bundle tab 8, page 147. And here the learned judge said, in relation to those matters which the claimant submits HMPO wrongfully took into account, I accept the submission made on behalf of the defendant that with the exception of those factors which are no longer relied upon, there is nothing which HMPO erroneously took into account. And this is despite the learned judge agreeing with us below, that's paragraph 142 of the judgment, that justification for the continuing policy must be based on evidence, not legal submissions on instructions. And we say this creates an extraordinary position in public law terms, because by implication, the submission on behalf of the defendant was that the respondent had taken into account factors that it was erroneous to do so. Because as recorded here at paragraph 144, the defendant submitted that with the exception of those factors no longer relied upon, there's nothing that was erroneously taken into account. In other words, they did take things erroneously into account, but they don't anymore rely upon them. We say that simply flouts almost every public law approach to considering the lawfulness of a decision based on whether relevant considerations were taken into account and irrelevant considerations were not. Reliance is a rather different matter to what was actually the basis for the decision at the time. And the significance of that error is illustrated by the internal review itself. And I wonder if I could ask the court please to go back to the supplemental bundle. And I think for what it's worth, I don't think I'll be returning to bundle A2, so that can perhaps go away as well. The supplemental bundle.
This is the seeming error that legislation was required, is it?
I'm so sorry.
Is this the seeming error that legislation was required?
That's a different error. At the moment I'm on the question about relevant and irrelevant considerations, but absolutely both of those we say are errors. So we're back to the internal review, which I went to very early in my submissions, which is quite a long time ago now, but we looked at this at tab 16.
Yes.
From page 176. And I took the court to page 182, option 5, which is the adding the third gender marker. And the court will see that there are 8 concerns. There's one that goes over onto the page, 183. There are 8 concerns listed. As we explain at paragraph 58A of our skeleton, 7 of them are, in the respondent's characterisation, no longer relied upon. They are the first, that the marker could cause offence; the second, that the marker might cause confusion with applicants who would interpret the category wrongly; the third, that there might be some inconvenience and embarrassment of the individual holder of an ex-passport; the fifth, that other customers might request an X in their passports or question whether HMPO should be asking what gender is at all; the sixth, that British passport holders with X may require additional consular assistance; the seventh, Section 22 of the Gender Recognition Act protects the privacy rights of transsexual people, and HMPO, as it were, to add an X to a passport, HMPO must have a declaration signed by the applicant that their individual gender situation will be referred to on their passport. It's accepted, not merely that's not relied upon, it's accepted that's simply wrong. And the eighth, over the top of page 183, evidence of gender diversity would be difficult to produce because there's no legal framework for those who do not recognise male or female. Self-identification would not be appropriate. Some of them are so wholly irrelevant. One questions, for example, such as the fact that other customers, this is the fifth one, may request X in their passports or question why gender's there at all, or whether it's proportional. I find that a very surprising consideration, given that in 2012, the ICAO was itself embarking upon a process of trying to understand, as a matter of consultation, whether actually there should or shouldn't be any gender marking in a passport, whether it was any longer justifiable.
I'm slightly puzzled, if I may say so, about quite where this is going, because, I mean, this took place, 5 years ago or something like that, and there's been any amount of water under the bridge since then. I mean, it's not as though you're seeking to attack this document itself. I mean, you'll be years out of time for doing so.
No, what I'm seeking to attack is the decisions based on this document. So we know that there is a decision shortly after this document saying we'll adopt option 1, do not.
Well, even that decision would have been many years ago, and I don't quite know how the question of whether your application was in time or not was eventually dealt with. But, I mean, and I see the problem somebody in your client's position has of trying to find an identifiable decision to challenge.
Yes.
But I mean, you can't have it both ways, can you? And then seek to go back into the whole prehistory of this whole dispute than try to identify a mistake of law 5 years ago and say that somehow invalidates everything now.
Well, we say we can identify that mistake of law 5 years ago. It is quite clear the sheer scale of matters which were improperly taken into account, but then no longer relied upon. We say makes it clear that a decision based on option 5 and those concerns clearly took into account 7 out of 8 irrelevant considerations. So that's my starting point.
Yeah.
Now, the next, and it just leaves just one, just in terms of the cost, for example, but cost, the fourth bullet point, is no longer relied upon in isolation. It might be suggested that those matters were then reconsidered afresh in relation to the Women Equalities Committee report. But we wrote after that report, and this is at supplemental bundle page 36, and this is the response. We wrote saying, it seems to us effectively, based on your response to that committee report, you don't rely upon all the matters that you relied upon in the internal review.
I'm sorry, where are you reading from?
I'm so sorry, I'm summarising the letter that we'd written to which this is a response.
Which is at page?
The letter that we had written is at tab 32.
Thank you.
And at page 256, paragraph 3, we note the fact that response only relies upon a narrower set of reasons for refusing to implement X
Just wait.
passports. I'm so sorry, I should have kept my eye.
Otherwise you're just reading. You finished reading before we turned the page.
So this is a letter from the appellant solicitors of the 8th of August 2016. So this is shortly after the government response to the Women and Equality Select Committee report. And we had waited for that report to be responded to before issuing these proceedings. We noted at paragraph 3 on page 256 that the response relies upon a narrower set of reasons for refusing to implement ex-passports than those in the response to the pre-action letter, and does not reiterate all of the points made in the internal review. In other words, those 8 concerns that I've identified under option 5. So we said, effectively, have those points been abandoned? And the response to that, after some chasing, tab 36, a letter of the 3rd of October 2016 from the Passport Office. Page 264, turning over the page, the 3rd paragraph down, just above the first hole punch, states in terms, the Home Office continues to rely upon all points set out in the internal review. And on that basis, we issued these proceedings and, of course, took the point that reliance on those 8 points was unsustainable and erroneous.
And I'm sorry, the date when these proceedings were started, I'm sure it's in the chronology somewhere, I just haven't got it at my
Yes,
fingertips.
I'm so sorry, it is, I can find it now, the
7th
20...
June 2016.
Thank you.
Oh, that's good.
Sorry, 17th.
17. Thank you very much.
So the proceedings were issued then, and then permission was granted in October 2017. And following that grant of permission to apply for judicial review, we see from the witness statements of Mr. Woodhouse and Miss O'Neill that there isn't any reliance in those witness statements on those points, nor in the summary grounds or detailed grounds for defending the claim. So, although, my Lord, I completely understand my Lord Justice Henderson's point, which is this is prehistory. Well, actually, it's not to that extent, because it's carried over. If they had said, no, we've reconsidered following the Select Committee report, and actually, our view is now based on the following 3 points, let's just call them administrative coherence, security in terms of fraud and security at borders. If that had been the case, then I wouldn't be having this debate with my learned friend, and I wouldn't be raising this point. But it's not, it's because there was a studious reliance upon those factors as confirmed in the letter that I've just taken, my lady and my lords, to from October 2016. And there's nothing to suggest there was any fresh decision taken between October 2016 and the summer of 2017. It's never been suggested that was the case. And that's why I go back to the point, which is, of course we can challenge the continuing policy, but equally we're entitled to challenge the points at which a decision has been taken to maintain that policy. We've done the best we can to identify when that might have been. And we know that the most recent decision taken after the Select Committee report and before the government decision, the response in July 2016, was to maintain all those points. So that's as far as my forensic trail goes. But I say it matters because one cannot simply get to the court and say, oh, I don't rely upon those matters anymore, when what is one is concerned with is whether actually the decision as was taken took into account irrelevant considerations. And my submission as it was below is that, frankly, holds below the waterline almost every argument based on decisions that have a continuing policy as a result of it. If Sir James or whoever it might be can simply stand up in court and say, oh, I don't rely upon that paragraph anymore. And that goes back to the point in relation to paragraph 144 of the judge's argument, which is, apart from everything that's no longer relied upon, there were no erroneous points taken into account. And we say that's a really troubling aspect of this case, and a much more fundamental point in principle, but certainly one that renders the decision, either the decision in 2013-14 or the decision in 2016, we say flawed and should be quashed. We don't accept at all...
That would merely drive everybody back to a reconsideration of the thing all over again.
Well,
If you're going to achieve any more than that, simply have a fresh decision and then whatever is to be taken into account is to be taken into account.
I entirely understand that, which is why this is my, as it were, set of fourth submissions rather than my first and second submissions. But I do make them nonetheless because actually the point of principle is a really fundamental one. And the way in which it was dealt with by the learned judge below is a really troubling precedent for the respondent or other public bodies to go about defending a continuance of a decision where a policy rather where a decision has been made to maintain it. So I take the point because it matters, not just in the scope of this litigation. I emphatically agree with my lordship, which is we do not want the Secretary of State simply to go back, make another decision that is adverse to the interests of the appellant, and then say, but more time is required in any event. That is not in anyone's interest. And of course that wasn't the approach that was adopted by the learned judge below, because his position was, effectively, I'll give you a bit more time now to get your house into order, but you've got to do it quickly. If you're going to go down through this sort of global approach and consider everything in the round, you've got to get on with it. We're now 18 months further down the line. You've seen what the review document that we've summarised the reviews says. And I place particular emphasis then on the total, we're setting an aspect of any consideration actually of ex-passports. It's as though they have simply stopped considering or reviewing that, notwithstanding that the do-nothing option back in 2013-14 was to keep it under active review.
How far is it appropriate to look at what has or hasn't happened in the last 18 months, given that this is an appeal against the judge's judgment and what he decided on the material before him? I mean, of course, the court wishes to be updated to know what has happened, but and you can't really, can you, get further fuel from inaction or otherwise over the last 18 months? And if you did seek to do so, you'd no doubt be met with the answer that government departments have had a lot of other things to think about over the last 18 months.
That is very much an answer that we're being met with. I entirely understand that. And I'm not seeking to
There
base...
might be a few things to think about over the next few months.
Well, so be it, but just to be serious about it, to go back, this is a state of affairs that has existed for 10, 20, 30 years. And so in those circumstances, we do say that, at least in 2014, there was some active engagement on the issue. Someone carried out an internal review. Now, you'll have seen from the underlying documents, that was by dint of the hard work of the appellant and PERS MP to try and nudge some action. But after that, everything goes remarkably quiet until there are various points where we issue a pre-action protocol letter or the like. But the reason I do rely upon what's happened since is because it goes to the legitimacy of the government's argument or the Secretary of State's argument, of the wait-and-see argument. Because you might have some more sympathy for that argument if the government were going to act with alacrity, or if this wasn't a new point that had never been pointed out to them before, that they couldn't have anticipated.
I mean, you're not inviting us to infer the government is acting in bad faith in putting the evidence it does before this court. Or
On the
anything
contrary,
of that kind?
no. On the contrary, we're delighted to have the evidence that it put. We didn't object to the evidence being put in. We agreed to that, as my lady will know. We were very clear and very helpful to have an update because, of course, in fact, that's what the learned judge below suggested should be the case. In other words, the government should get on and do things. But we do point out in the review note, and I hope we've summarised it in a neutral and fair way, where matters have stalled. And effectively, where matters have stalled is ex-passports. And we're at a point now where we still don't have a call for evidence in relation to non-binary gender, and who knows how long that will take. So when I go back to my Lord Justice Irwin's point, which is, as it were, do we want a reconsideration? No, we obviously want a very clear finding that there has been, and continues to be, a breach of the appellant's Article 8 rights, or Article 8 read together with Article 14. But this point is made as a backstop in any event, firstly because of the point of principle and importance, but it's certainly not an invitation to the Secretary of State to say, well, actually, I can start with a clean slate and spend another couple of years thinking about it carefully. It's the sheer scale, we say, of the matters that were not taken into account. And just the final point in relation to the learned judge's approach, which is, he says, well, I would have concluded under the Supreme Court's Act, the Section 31(2)A, that the error was highly unlikely to have made no difference. We simply say, given that 7 out of 8 of those points are abandoned, and before this court at least, the last of them, the cost just of passports, no longer appears to be relied upon, we say that it is quite clear that the interests of a lawfully taken decision should prevail in that circumstance. One can't simply say it would have been the same if the Secretary of State at various points had not taken into account those various completely irrelevant matters. The final point, in terms of misdirection that my Lady King pointed out, Lady Justice King, is in relation to the suggestion, first of all, that primary legislation would be required. Now, we accept, of course, as I pointed out, that the internal review made it clear it wouldn't be, but I've already taken you to the response to the Select Committee, which is Supplemental Bundle 30, page 252, and the implication that to introduce a third category denoted by an X in the passport would require a change in primary legislation. If you read that, as it were, as I said, without the prism of these proceedings, as anyone would who is simply reading that response, that indicates that primary legislation was required before an X passport could be issued. That is clearly wrong. It is a separate question as to whether legislation will be required in relation to any consequential matters that the government may wish to consider legislating on. But the X passports themselves are under the prerogative and can be issued without primary legislation. We don't accept the suggestion made at the paragraph 16, little Roman 5, footnote 2 of what is meant here. You don't use the language of not possible or can't or would require primary legislation if you mean we can do it under our prerogative powers, but we think that we ought not to. And that's not what's being said here in the response to the Select Committee report. But if there were any doubt about that, our concern is in no way assuaged by the way in which a parliamentary question was answered in June of this year. And again, we are grateful to the Secretary of State for putting this in Mr. Entwistle's evidence. And this is the supplemental bundle, tab 7A. We've seen some of the appendices to it. We've seen the survey and the consultation on reform of the Gender Recognition Act. His witness statement itself, which we draw on very heavily for the purposes of our note on the review, which is, of course, many-faceted. Paragraph 19, which is page 89, he refers to a parliamentary question that was received since the witness statements of Miss O'Neill were lodged, so that's back in October 2016. Although the date isn't given for this question, it's in fact the 24th of June 2019. And so the question is, for what reasons the government doesn't issue non-gender-based passports for people who do not identify as either male or female. And the answer by the Secretary of State is, United Kingdom legislation only recognises two legal sexes or genders, male and female. There is no legal recognition of a third gender. Her Majesty's Passport Office can, therefore, only issue passports indicating male or female. On no view is that accurate. And so the fact that the Secretary of State's legal advisers in these proceedings clearly understand, and the author of the internal review back in 2013-14 clearly understood, that passports fall under the prerogative and legislation isn't required, doesn't mean that an error, a fundamental error, hasn't been made by the Secretary of State in finding that there is no power to issue a passport with an X marker in the absence of UK legislation recognising a third gender. There is another misdirection point that we make in relation to Mr Woodhouse. For speed, can I just give my lady and my lords the reference to that? It's paragraph 59 of our skeleton and paragraph 24 of our post-hearing note, and that's at core bundle 13, pages 236 to 237, and the paragraphs in the judgment to which that point refers. It's about a misunderstanding, we say, of European law, is paragraphs 145 to 147 of the learned judge's judgment below. Finally, moving away from then the two grounds, common law grounds. So the first is irrelevant considerations wrongly taken into account, and we've set out in our skeleton relevant ones not taken into account, such as the engagement of Article 8. The second then is in relation to misdirections, the fundamental misapprehension as to whether primary legislation was required. The third is simply that the learned judge didn't give any independent consideration to the rationality of the policy, regardless of the conclusions on Articles 8 and 14. That's paragraph 136 of the judgment and paragraph 64 to 65 of our skeleton. And I don't want to repeat the substance of what we say, but the key difference here, when we're talking about the rationality, is that when one looks at the respondent's position, an inordinate amount of weight is placed on the width of the margin of appreciation or area of discretionary judgment. But that simply doesn't apply in the same way when weighing the rationality or the reasonableness of the policy. So we say that the learned judge should have approached this as a pure matter of, as it were, public law and common ground, and considers the fact that it is striking that the legality of a decision and a policy, which is admitted effectively, was taken on the grounds of 7 out of 8 of those factors being erroneous, and which are no longer relied upon before the hearing and no longer relied upon before this court. We say that is a clear pointer that the decision to maintain the policy was not based on any sound reasoning. And we do say that if independent consideration had been given to this point, the maintenance of the policy was irrational. And the reliance upon the what's described as the entitlement of the respondent to consider matters further, that's paragraph 130 of the judgment, we say is wrong for the reasons already addressed. The presumption is that it's not possible or appropriate to look at passports in isolation. We've set that out. And the reliance upon concerns about security simply failed to recognise the lack of any evidential basis for those concerns. So viewed through the prism of the classic proportionality and rationality of policy, we do say that there is no good reason why the policy should be as it is, and no good reason in particular for refusing to afford the issuance of X passports. Well, can I just, my lady, can I just check behind me in case I've missed any particularly salient point? I'm very grateful. No, I'm told that I may have made it with minutes to spare. Thank you. And can I apologise again for speeding up? It's a matter of some complexity, as I hope the court will understand, but we do want to get the full detail of the matters across as well as the points of principle. So I apologise for my perhaps uneven pace, but I'm sure Ms. Cars-Frisk will make up for it with more even-handedness. Thank you. Is there anything else?
Thank you very much.
I'm grateful. Thank you.
Yes, thank you.
Yes, my lady, my lords, what I propose to do is to highlight what we think are some of the most important points in our written submissions that you have at Core Bundle tab 5, accompanied, as you will have seen, with a witness statement from Mr. Kyle Knight at tab 9 of the supplementary bundle. And I propose to do that largely by reference to the same subheadings that we have in our written submissions. First, the affected class. Here I would just like to put a little bit of flesh on the bones in terms of the significance of the group of people that stand to be affected. My learned friend Ms. Gallifant already referred to an important survey, the LGBT plus survey in 2018 in the United Kingdom, where she mentioned that 7% in that survey identified as non-binary. And it might be helpful to just set that in the context of those who responded to the survey as being transgender, with non-binary being here for these purposes a subset in the sense of falling under the umbrella term of transgender. So looking here at transgender as a term that refers to persons whose gender identity does not reflect the sex that is recorded or assigned to them at birth, their biological sex. So for these purposes, including binary transgender people and non-binary. And
paragraph 15 of your
it is paragraphs 11 and 12, and then, I'm very sorry, my lord, you have caught me out here in the sense of not having the particular paragraph. Yes, you're absolutely in the right area, my lord, yeah. So, looking at the percentage of all the transgender people who responded, who classified themselves as non-binary, we are talking about 52%, so quite a chunky proportion. And just for your note, you may have seen it, you have the survey in the supplementary bundle at tab 40, page 277. And then there is a second survey, an American one, which we point to at paragraph 14 of our submissions, carried out in 2015 by the National Centre for Transgender Equality, and out of nearly 28,000 transgender people, as many as 31% identified as non-binary. So it gives you perhaps a little bit more of an idea of how non-binary persons then compare to a larger group of transgender and in particular binary transgender people. Well, so much for that first heading. Our second heading then looks at legislative developments elsewhere, internationally, and the impact of such developments. What do we know about that? Well, Ms. Gallifant has already mentioned a number of countries that allow ex-passports of the kind that the appellant would wish to be able to have. We have provided a summary in paragraph 22 of our submissions, and I hope this is all of them: Australia, Austria, Canada, Denmark, India, Malta, Nepal, the Netherlands, New Zealand and Pakistan. Quite a number. But it's important, we say, that actually the international trend doesn't stop there, because if one looks a little bit more broadly at developments that really go to, or that recognize the gender identity of non-binary persons for the purposes of various official documents, one has other important developments too. So Argentina, since November 2018, it's been possible to obtain a birth certificate with neither a female nor a male gender marker. Importantly, if we stop the clock as at October this year, in the United States, 17 states, more than 1/3, had decided to introduce X or similar gender marker options for official forms of identification. In Germany, from January this year, you now have a third category in the amended personal status law, described as diverse or diverse, for official documents. In June this year, you have the Icelandic Parliament introducing a new statute that will allow people to change their gender on official documents based on self-determination, including an X option for a gender marker. And finally, we also have the reform in Uruguay that is actually not mentioned in our written submissions, but we entirely accept is there, allowing a non-binary option for a gender marker on official identification documents based on self-declaration. A significant trend. But what then do we know about the effect of these developments in those countries where these changes have been introduced? Well, very little. We say it's striking that there is no evidence, no data that we are aware of to suggest that there have been problems, either in terms of identity fraud security or border security, or indeed evidence of the sort of administrative complications that are referred to by the Secretary of State. And perhaps that isn't surprising in the sense that, as we know, as Ms. Gallifant mentioned, the International Civil Aviation Organization has for some time considered that it was perfectly, or is perfectly acceptable to have X markers in passports. And we know the United Kingdom seems to have no difficulty admitting persons travelling to the United Kingdom with such passports, even though we here, or the passport office here, doesn't issue such passports. Well, we do have some evidence, actual positive evidence, of passports with a non-binary gender marker working well, and it's only right to mention that. We refer to that in paragraphs 39 and 40 of our submissions, and also in paragraph 9 of Mr. Knight's witness statement at tab 9 of the supplementary bundle. This is referring to individuals with passports issued by Nepal with a marker O for other, who have been able to travel to multiple countries with no apparent difficulty. On the other hand, it is right to have very much in mind, and we deal with this in paragraphs 17 to 21 of our submissions, the very real risk that non-binary persons, such as the appellant, will suffer harassment and discrimination where they have travel documents that don't, in terms of the gender marker, reflect their gender identity or appearance. And this is important, of course, in relation to the issue of the engagement of Article 8 and in other respects. We have evidence, for example, of a large survey of transgender people, and again using that term in the umbrella term sense, carried out in the United States in 2000, the National Transgender Discrimination Service that we refer to. and this is a point we make in paragraph 18 of our submissions, there it was found that 40% of those who presented identity documents that didn't match their gender identity reported being harassed as a result. Now, it's right to say that that survey was primarily directed at those who were transgender persons with a binary gender identity. But the survey also looked at non-binary persons. They had a category described as, and I quote, gender non-conforming people. And in relation to that group, the statistic for those who suffered harassment when their identity documents didn't fit with their gender identity or their appearance was even higher than for binary transgender persons, at 47%. Now, all of this one gets from the survey itself, which you don't have printed out, or at least you don't have the whole survey, but it's possible to click on the link and find it. However, I hope you do have a printed out version of the key parts of the survey that I've just referred to. Should be at the back of tab 9 of supplementary bundle 9, and it's really for your reference.
Want us to turn it on?
I was going to give you the references, but I'm of course happy for you to turn it up. So it's page 24, first of all, that defines the gender non-conforming class.
Sorry, tab.
It should be at the back of tab 9 of supplementary bundle B.
It isn't. No. We have the statement of but not.
I'm sorry, then it should be put there, my fault. I think I must have somehow imagined it would automatically
It's just arrived.
fly into the back.
Just
of
arrived
it
in
now,
German.
thank you.
Yes.
There we are. Insert at end of supplementary bundle tab 9. Could have done that. What was I thinking of?
So, on its top left-hand corner, page 24, it's the pagination. Right-hand column under the heading Analytic Gender Identity / Expression Categories. And the fourth paragraph, halfway down, says we also created a gender non-conforming category.
Sorry, I haven't
14%.
found it yet.
Yeah.
What's the internal page?
It's 24, top left-hand corner.
Thank you.
So right-hand column, about halfway down, we also created a gender non-conforming category. 14% of the sample identified as gender non-conforming, which generally included those who strongly identified as genderqueer, two-spirit and third gender, among others. And then the percentage that I highlighted, 47%, is on page 153 of that clip. Top right-hand corner, under the heading Harassment and Violence when Presenting Incongruent Identity Documents. And halfway down in the left-hand column, one has the 40% of respondents who presented gender incongruent identification reported harassment. So this is now referring to binary transgender persons. And then in the right-hand column, halfway down, just before the graph, gender non-conforming respondents reported more harassment due to gender incongruent identification, 47%, than their transgender peers, 40%.
Thank you.
Moving on then to our third heading, which refers to recent developments in international and comparative human rights standards. There is a good deal of material, but in my half hour I will of course look at it as sparingly as I can. It is right for the court to be aware, we think, of an advisory opinion issued by the Inter-American Court of Human Rights, which strongly endorses, among other things, the right to gender identity and to have identification documents which reflect that gender identity. And if I could ask you to turn to International Materials Bundle at tab 4. You have that opinion there.
Can you help me again, please, to where you are in your written submissions?
Yes, and I am kicking myself for not having noted that down in my notes, but I will find it. Yes, my junior very helpfully reminds me it's paragraph 78 on page 96.
Yeah.
It's a lengthy document. You may care to note it was an opinion sought by Costa Rica, as one sees from page 67, probably no need to turn it up. Pages 71 to 76, no need to look at them certainly in any detail, set out the very large number of persons that had made written submissions and oral submissions. And just for your note, again, I don't propose to dwell on it, but page 69, you see, identifies the questions that the court was asked to look at and the particular articles of the American Convention on Human Rights that were in play. And the relevant articles are set out in footnotes 4 to 7, on page 69, and you will see that they reflect, in very important respects, the articles that we're concerned with in the European Convention. Now, moving on briskly to the concluding parts, I think one can go to page 117, paragraphs 112 to 113, page 117. And it's really all about the very great importance that the court attached to gender identity and for that to be reflected in identity documents. At paragraph 112, in this way it can also be inferred that the right to recognition of gender identity necessarily includes the right that the personal information in records and on identity documents should correspond to the sexual and gender identity assumed by transgender persons. Thus, the Yogyakarta Principles establish the obligation of states to take all necessary legislative, administrative and other measures to fully respect and legally recognize each person's self-defined gender identity, and to ensure that procedures exist whereby all state-issued identity papers which indicate a person's gender/sex, including birth certificates, passports, electoral records and other documents, reflect the person's profound self-defined gender identity. Then at paragraph 113 there's a reference to the European Convention on Human Rights. And realizing how time flies, may I also just refer the court to paragraphs 115 and 116, very much reflecting what we have already seen. Now I note that the Secretary of State's skeleton argument in paragraph 26 2 suggests that there's no reason to think that the court's analysis applies to non-binary gender identity. Well, our response to that is that there is every reason to think that the opinion does so apply, because the reasoning, we say very clearly, would apply to those who identify with a non-binary gender. And in fact, I'm not asking the court to turn it up, but if one looks at the reference to gender identity at paragraph 94 on page 111, referring to gender identity as self-defined, and then reflected in the paragraphs to which I have already pointed, it is in our submission tolerably clear that this opinion does intend to include non-binary persons as well. There's also a reference to, and I quote, diverse gender identities in paragraph 115 on page 118. The next topic under this heading is the so-called Yogia-Carter principles. And the court will recall that those were mentioned in paragraph 112 of the Inter-American Court's advisory opinion that we just looked at. We deal with these at paragraphs 58 to 61 of our submissions, and you have the principles themselves in Authorities Bundle Volume C, tabs 57 and 58. And again, in the interest of saving time, I'm hoping to skate through what we wanted to say rather than inviting the court to look at them specifically now. They are a set of principles agreed upon by a large number of eminent experts. You have a reference to that in the introduction to the principles, if I can just give you the reference, at Bundle C, tab 57, page 1824. And in particular, I should say, you have a reference there to how the principles set out to describe existing international human rights norms rather than to prescribe what the law or what those norms should be. And that's an important point when one bears in mind what I think Sir James would say, which is, well, these are not legally binding. And of course it's right, they're not treaty obligations or anything of that sort, but they do set out to explain what is already there by way of international standards. And you have a list of the people who contributed in relation to each set. Now I say each set, you have the original principles signed up to in 2007, and then an augmentation of those with 9 further principles in 2017, referred to as the Yogia-Carter principles plus 10. So they are in Bundle C, tab 58. These principles have been cited not only, as we just saw, in the Inter-American Court's opinion, but in various fora that we refer to in paragraph 61 of our submissions, not least by the UN High Commissioner for Human Rights. And the principles, the importance of them for our purposes lie in what they say in its original principle 3, and then the plus principle 31, which specifically refer to the need for gender identity to be reflected in identity documents. Perhaps we should just turn up
I think that would be helpful.
Principle 31 at tab 58 of Bundle C. Principle 31 at page 1863. 3. Everyone has the right to legal recognition without reference to or requiring assignment or disclosure of sex, gender, sexual orientation, gender identity, gender expression, or sex characteristics. Everyone has the right to obtain identity documents, including birth certificates, regardless of sexual orientation, gender identity, gender expression, or sex characteristics. Everyone has the right to change gendered information in such documents while gendered information is included in them. And at point C, reference to while sex or gender continues to be registered, the states shall, this is all a reference to what states shall do, ensure a quick, transparent and accessible mechanism that legally recognizes and affirms each person's self-defined gender identity, and to make available a multiplicity of gender marker options. The principles we invite you to think certainly have considerable persuasive force.
Certainly the list of signatories I think, includes some very eminent names.
Yes, indeed, I seem to recall persons like Manfred Novak and Mary Robinson.
Or Judge Edwin Cameron of the Constitutional
Yes.
Court of South Africa was one that struck my eye.
Indeed, yes. What about the case law? I look nervously at my watch because I had hoped to show the court a couple of cases.
Well, just a moment, I think we're probably okay, but Sir James, presumably, providing you get started first thing tomorrow morning, you're happy?
I'm very grateful.
So take us to your two cases.
I will. I was going to take you to a case called Zim and Pompeo, which is the Colorado District Court. It is a decision that came after the judge gave his judgment in this case. And the reason it's particularly important is that one sees arguments not dissimilar to the arguments put forward by the Secretary of State in this case, being given short shrift by the Colorado court. Then in addition, of course, one also has the recent European cases that are important, where I propose to go to the Belgian Constitutional Court's very recent decision. But anyhow, Zim and Pompeo, you have at tab 8 of the International Bundle, decision of September 2018. So, giving the court the basic facts of that case, in that case, Dana Zim was an intersex person who wanted a gender marker X in their passport. That was denied to them by the US Department of State, and Dana then brought proceedings under something called the Administrative Procedure Act, which seems to have, I comment, have incorporated procedures not dissimilar to some of our public law procedures. And it was claimed that the binary-only policy of the Department of State was contrary to that act and also to Dana's due process and equal protection rights under the Fifth Amendment. Interestingly, the court had already once ruled that the department's binary-only policy was unlawful, being irrational, but when the department reconsidered, it came to the same view, didn't amend the policy, and it then ended up back in court. And it's of some interest, we say, that as one sees from page 382, the department had effectively offered Dana a choice of gender as long as it was binary, either male or female. And this is the key point. That choice had been offered, notwithstanding that depending on the choice, Dana might end up with inconsistent documents, i.e. a passport that says one thing, male or female, and a driving license that says something else. This is what we derive from the first paragraph on page 382. I wasn't going to read it out. Then at page 388, one gets 5 reasons that the department relied on for their gender policy, i.e. for not permitting a non-binary X marker in passports. And the first 3, as one sees the judge identifying further down in the decision, are really all about consistency between the passport and other official documents. I don't know if the court would want a moment just to glance at those without me drearily reading them out.
No, but I don't think we need you to read them
No.
out. Thank you.
The 4th point was about alleged difficulty in identifying the relevant group that would benefit from a non-binary passport, and then the 5th point, that it would all be inconvenient. The judge says robustly at the bottom of page 388, looking at the proffered reasons and cited evidence provided by the department, I find that the department's decision is arbitrary and capricious. And at 389, dealing with reasons 1 through to 3, reasons 1 through 3 essentially boil down to the same argument. The department needs to maintain the binary gender classification system for passports because this will ensure accuracy and reliability in cross-checking gender data with other identity systems. And if one moves down to the next paragraph, the court says, in that order, I noted that the department's argument that the binary gender policy helped to ensure the accurate identification of passport applicants stroke holders failed when one looked deeper at the evidence in the administrative record. For example, I noted that the department undermined its purported rationale when it informed Dana that Dana could receive a male passport if Dana provided a physician's letter attesting to that gender, even though Dana's Colorado driver's license listed Dana's gender as female. And then jumping to the last sentence on that page, by allowing this means of gender designation on the passport, the department made it apparent that it did not actually rely on other jurisdictions' gender data to verify passport applicants' identities to the extent it argued. Reflections one may think, and we would invite you to think of the sort of issue we have here, where consistency is relied on as important by the Secretary of State, but we know that binary transgender people here can change their passports without otherwise changing their legal status, and so there can be inconsistency in that sense between other official records and a person's passport. Page 392, if I may, I would just draw to your attention the observation the judge makes in the 5th line of page 392, where he says, I find that requiring an intersex person to misrepresent their sex on this identity document is a perplexing way to serve the department's goal of accuracy in integrity. In sum, taking the department's proffered rationales that I previously determined were inadequate, with the new evidence in the administrative record regarding the growing body of jurisdictions that allow for a non-binary gender marker, I find that the department failed to show that its decision-making process regarding the policy was rational. I suspect there is no need to look further at the court's reasoning on justifications 4 and 5. Certainly I can see that justification 4, it may be said, was looking specifically at intersex persons, but the rest of the reasoning in our submission would plainly apply also to someone who self-identifies as a non-binary person.
The district court gave an injunction to the department.
Yes.
But passports must be a federal matter. Betokened by the defendant here. Do we know what happened? Was there a further appeal? Because the district court can hardly bind the...
Your junior knows the answer to that question.
Yes. Yes. I'm very glad that I was prompted to make that point, my lord. Yes, an appeal is pending in the, is it the Seventh Circuit? We'll check which circuit it is, my lord. And of course, if we find out the outcome or there's any relevant development about that, we will draw it to the court's attention. Tenth. I'm sorry. It's the 10th Circuit. The European jurisprudence, then, the court knows, my own friend Miss Gallifant showed you the German case, and I think the court has seen from our submissions too that we have an Austrian case and a Belgian case, and of course Miss Gallifant took you to the Dutch case. So the Belgian one then, the Belgian Constitutional Court, which is the next tab of the International Materials Bundle. Here, a number of complainants complained about new legislation that had been designed to enable gender recognition without any medical criteria needing to be satisfied. But the complaint was that that didn't go far enough because it didn't include provision for non-binary or a non-binary gender marker on birth certificates. That was the complaint. And the court found in favour of the claimants on that point. Going to page 442, if I may. One sees the court at B.6.6, about the middle of the page, saying, well, I should probably start just above that paragraph. In the light of these objectives, and that's referring to the objectives of the legislation, the legislature did not use a relevant criterion for distinction when it made provision for the ability to change the registered sex for people whose gender identity is binary, and did not do the same for people whose gender identity is non-binary. For both categories of people, the principle of self-determination must dictate that when the sex registered on a birth certificate is being changed, the relevant individual's gender identity is taken into account in the same way for both categories, whether it be binary or non-binary. Furthermore, the need to make other changes to the legal system that take into account the needs of people whose gender identity is non-binary does not justify the fact that such people, unlike people whose gender identity is binary, are forced to accept a registered sex on their birth certificate that does not correspond to their gender identity. As the European Court of Human Rights has held, it is reasonable to require society to accept certain inconveniences in order to enable people to live in dignity and respect in accordance with the sexual identity they have chosen at the cost of considerable suffering, in reference to Goodwin. Now, here, of course, as Miss Gallifant has explained, it is not necessary for the state to amend or reform large chunks, or indeed any chunks, of legislation in order to provide to the appellant what she asks for in this challenge. So the appellant's case, we would respectfully suggest, is a fortiori, but it is nonetheless interesting that the Belgian court was so clear that sometimes there may have to be inconvenience, as it was put, to allow persons that which they are entitled to under their right to respect for private life and non-discrimination. Where does it get us to? This is the very last thing I will say. It gets us, I hope, to at least, or all of this gets us to at least two points. One, I hope the international materials put beyond any doubt that we have evidence of a clear, significant trend, indeed an accelerating trend, one may think, towards recognizing the need to protect those who have a non-binary gender identity. And secondly, we hope that these materials will inspire this court to agree with the appellant that gender identity, whether it is binary or non-binary, is at the very core of the values that Article 8 sets out to protect, so that in respect of those values, any action, or more pertinently, inaction by the state, deserves the court's anxious scrutiny.
Thank you very much indeed, that's really nice stuff. Very well, 10:30.
Stand up and speak for 6 minutes.